Ready, start. The ocular account gets proper corroboration from medical and other circumstantial evidence, full stop. While reporting the matter, complainant stated before police that her husband ABC hit her father with stone, due to which he sustained serious injuries on his head, causing his death while he was being taken to hospital for medical treatment, full stop. Dr. PW6 has reported two wounds on head of the deceased, that is on his occipital and left temporal regions, with blunt object, hence, medical evidence is in conformity with the contents of FIR, full stop. The occurrence took place in a hilly area, as is evident from site plan and photographs of the spot available on record, where stones are abundantly available, one of which lying nearby was lifted by appellant ABC and hit therewith the deceased during the scuffle, full stop. The blood-stained stone with which the deceased was hit and clothes of the deceased have been taken into possession. Besides, the IO has also collected blood-stained earth from the spot, full stop. The, the mentioned objects have been examined through FSL, and serologist has opined in his report that it was human blood of the same group, full stop. Thus, circumstantial evidence on record duly corroborates the complainant's version and also validly confirms the mode and manner of the occurrence, to the extent that deceased was killed through blows of stone in his residential house, full stop. Para. Although complainant has charged both the appellants, but she has attributed the role of hitting her father with stone to appellant ABC, whereas charged appellant XYZ by stating that he had caught hold of her father at the time when appellant ABC was giving him stone blows, full stop. As regards the role of appellant ABC, he is specifically charged for giving stone blows to the deceased, which proved fatal and caused his death, full stop. Prosecution has proved the above allegation against appellant ABC through confidence inspiring evidence, and by analyzing the material available on record, no opinion could be formed other than that the deceased had died due to the head injuries he had sustained at the stone blows of the said appellant, full stop. However, keeping in view the peculiar circumstances of the present case, we do not find ourselves in agreement with the findings of learned trial court that he had committed qatl-e-amd of deceased punishable under section 302B PPC, full stop. The admitted fact on record is that the appellants had come to the house of deceased unarmed, just for the purpose to take the complainant back to their house despite disagreement of the deceased, hence he entered into altercation with them, which turned into a sudden fight, full stop. The above mode and manner of the occurrence suggests that neither the appellants had come there with any pre-planning, nor they had the intention to kill the deceased, full stop. All that had happened had occurred at spur of the moment, wherein stone was used by appellant ABC, and unfortunately the blows thereof took the life of deceased, full stop. If he had the intention to kill the deceased, he would have come there duly armed with any kind of weapon, that is pistol, knife, etc. Full stop. In addition, the parties belong to same caste and they have female relations with each other. Besides, there is nothing on record to suggest previous enmity or hatred between them, full stop. In such circumstances, conviction of the said appellant under section 302B PPC by trial court was not a correct conclusion, rather the act of the said appellant falls within the definition of Qatl Shabi-Amd, which is an offence under section 315 PPC, punishable under section 316 PPC full stop. It would be appropriate to reproduce section 315, PPC for convenience full stop.